Hello friends, this is PP and welcome to Law for All. In this video, we're going to be learning about how to draft a legal notice. A legal notice essentially is a notice that is sent by an advocate on behalf of his client. Now, before we get into the video, I also would like to point out that if you're interested on various subjects under the Indian law, interested in learning about various subjects under the Indian law, then I've left some useful links in the description section of this video. So feel free to check them out if you're interested. Now, getting into the video, a legal notice is essentially, as I've previously pointed out, is a notice that is sent by an advocate on behalf of a client. There is no mandate of law that a notice has to be sent by a client only through an advocate. A person can also send a notice on his own accord without the assistance of an advocate. That also is permitted under law, but then again, it would not be a legal notice altogether. For that matter, I would also like to point out that there is no mandate under the law wherein a legal notice is required to be issued. There is no specific provision under the civil law, at least, that you have to issue a legal notice for the purpose of filing a civil suit. A civil suit can also be filed directly so long as there is a cause of action. But there are certain specific provisions of law, certain specific enactments of law which require a specific legal notice to be issued. Like, for example, the Rent Act requires that a notice for the purpose of recovery of rent, a specific notice, a 30-day notice has to be given to the opposite party, to the tenant, if the landlord desires to file a suit or an application for the purpose of eviction of the tenant. Likewise, similarly, the Negotiable Instruments Act also provides for a notice to be issued by the complainant to the accused, calling upon the accused to make payment as regards the check amount within a period of 15 days from the receipt of notice, failing which the complainant shall be entitled to pursue a legal complaint before the judicial magistrate first class. So therefore, there are certain provisions of law which require the complainant to, or the plaintiff as the case may be, to issue a specific notice demanding or making a specific demand. But otherwise, the civil law does not provide for any provision or any mandate wherein a legal notice has to be issued. A legal notice generally is issued by an advocate on behalf of the client for the purpose of soliciting a settlement. For this, a notice is issued so as to either invite a settlement or reject a settlement altogether, so that a civil suit or legal remedies can be availed of. So therefore, legal notice in such circumstances is issued. So now we'll get into the video and we'll see as to what all are the essentials of a legal notice and how all a legal notice is to be drafted. Now, now this is a demo legal notice that I've already prepared for you guys. I've excluded out the important excerpts, for privacy reasons. Now, this is, as you can see right here, is the letterhead of the advocate who's issuing the notice. Now, one thing to be kept in mind is that the letterhead has to be specific and proper. The letterhead has to have addresses, and the letterhead also is required to mention contact details of the advocate as well. But now this aspect is also very important because I'm sorry, this aspect, as I pointed out, is very important in a legal notice because the letterhead of the advocate has to be clear so that the opposite party can respond to the advocate if in the event he wishes to contact the advocate. So therefore, the letterhead has to state the name of the firm or the advocate, as the case may be, clearly, along with the office address and the phone number or contact number, as the case may be, so that the opposite party can contact the advocate and reply to the legal notice. Now, it also has to, the date on the legal notice also will have to be stated, the name of the person will have to be stated, and then according to the legal notice is to be commenced. Now, one more aspect that I wish to point out here is that a legal notice can be sent either by registered AD or either even by courier. Uh, there is no specific method of issuing a notice. The concept is that a notice can also be personally tendered to the opposite party. So long as the opposite party is willing to receive it and sign an acknowledgement, there is no need for a notice to be sent only by registered AD or only by courier. It can be sent in whichever manner please, so long as the opposite party is willing to acknowledge its receipt. The reason why it is sent via registered AD is because the receiver acknowledges the receipt of the notice on the registered AD card, which is then returned back to the sender, and that becomes a document of proof as regards the opposite party having received or refused to accept the notice. So that is the reason why we send notices by way of registered AD. Now, getting into the notice, the first paragraph should be like so. Under the instructions of my clients, namely so and so, residents of so and so, I have to address you as under. Now, this is the system that is generally followed. You can also follow a different system. Like, for example, I am concerned for my client, Mr. So and so, who is the resident of so and so, and accordingly, I have the privilege of addressing you upon his instructions. That is also a system that is followed, and that is also a system that is used rather by many advocates. I personally prefer to use it this way. Now, proceeding further, every paragraph in the notice has to be prefixed with the statement "my client state." This is a very good practice because the opposite party has to know that the statements in the notice are coming directly from the client and they're not created or fabricated by the advocate. When this phrase is always prefixed before every paragraph, uh, the opposite party understands that the client is instructing the advocate specifically to state such statements in the notice, and it also sort of gives the opposite party, it also does not incite the opposite party. The opposite party understands that the advocate is saying whatever it is that he's saying based upon what the client is instructed. So therefore the advocate's image is never tarnished, or his image is not sort of maligned in the eyes of the opposite party, and so that sort of helps in inviting a settlement in a better fashion. Now, this specific notice that I've issued, that I'm showing you at the moment, is a notice issued by the landlord to the tenant for the purpose of payment of, for the purpose of recovery of rent. That is, the tenant has defaulted in making payment of rent, and so therefore the tenant is issuing a statutory notice. I'm sorry, the landlord is issuing a statutory notice to the tenant, calling upon the tenant to make payment of the rent from of a specific period, in default of which the landlord should be constrained to pursue civil remedies before civil courts. So now I will not go through the contents of the notice. If you guys wish to see as to how the notice is drafted, then you can pause and you can go through the language that has been used in the notice. But essentially, what you have to keep in mind is the fact that you have to always prefix your statement by saying that it is that you are stating whatever you are stating in the notice as per the instructions of your client. Now, proceeding further, uh, an important part of the notice is that you have to state as to what it is that you want from the opposite party, as to what it is that you are trying to convey to the opposite party. That is always stated in the last paragraph. That is, the last paragraph is so: my clients therefore instructed me to issue this legal notice to you, which I hereby do, calling upon you to pay a sum of rupees so and so, being rental areas which are due and payable within 30 days of the receipt of the notice. Your tenancy also stands terminated at the end of the statutory period, and you are hereby called upon to hand over peaceful and vacant possession of the premises to my client within a period of 30 days from the receipt of the notice, failing which my client shall be constrained to file a suit for eviction as against you under the relevant provisions of the Goa and Due Rent Control Act. So this is how generally the last paragraph is required to be, that you give the opposite party you instruct or rather you intimate the opposite party that the opposite party has to do so and so within a specific period, failing which will be constrained to approach to avail civil remedies. Now, in this notice, what is important is the time limit. You have to fix a specific time limit within which the opposite party has to act, because if the opposite party does not act within that time limit, then it gives you an excuse to pursue legal remedies. It gives you a cause of action. So therefore, a specific number of days has to be mentioned. Preferably, it should be 30 days, because it gives the opposite party ample time to react and respond to your notice, or to sort of abide by the contents of your demands of your notice. So that is also another important factor that you have to keep in mind. uh, you can also frame the last paragraph differently. That is, if in the event you are issuing a notice for the purpose of inviting a settlement, then you can always state in the last paragraph that you are hereby called upon to settle the matter amicably, or that you are hereby called upon to meet me in the office, or something of that sort for the purpose of settlement. It is not always that you have to give the opposite party an ultimatum. You can also ask the opposite party and to come and sort of invite a settlement. So you can do that also. That is also possible in a legal notice. It will not hamper your legal remedies. If should you want to avail them subsequently if the notice fails. So that is what also an important factor that you have to consider in a legal notice. Now subsequently you have to sign as an advocate, and this part also is very important now, especially in the present nowadays. This part of the notice is in vogue, in the sense that you have to clearly state that you are issuing this notice under the instructions of your client, and you have to obtain the signature of your client. So what that would do is that it would act as an estoppel as against your client from saying that the notice was not directed to be issued by him, because quite often it so happens that if the advocate has faulted somewhere, or if the client thinks that the advocate is faulted somewhere, then the client then alleges as against the advocate, and then prefers complaints even before the consumer forum for deficiency in service. So therefore, if the signature of the client is taken, then it stops the client from subsequently saying that he did not read the contents of the notice. If in case the client does not understand English, then it would also be a good practice to state that that the contents of the notice have been read over and explained to the client in whichever respective language. So that is also something that you can do. So this is how a legal notice is to be drafted. And yeah, I hope that I've been able to help you. If you like the video, please kindly do give this video a like. Do share this video with your friends, and subscribe to this channel for more such content. Until next time, thank you for watching.